May it please the court, Brandon Christian for the appellant in this case, the state of Florida. I'd like to reserve 2 minutes for rebuttal. The state in this case is asking the court to reverse the lower court's entry of a judgment of acquittal on the charge of manslaughter in favor of the defendant and to remand the case with directions to enter a judgment against the defendant for that offense. And if I refer to the defendant as the appellant, I apologize. Usually we're on the opposite side of the case. So the standard of review for this issue is de novo, and basically the question presented is whether the state presented sufficient evidence at trial from which the jury could find the defendant guilty as a principal to either manslaughter by act or manslaughter by culpable negligence. The testimony at trial, the pertinent testimony showed that this defendant and a friend had heard about the idea of ripping off a drug dealer, and so they talked about this frequently, and then eventually one afternoon, January 16, 2012, this defendant calls the friend and says, hey, he wants to steal some weed. And so this defendant then calls someone that he knew, the initials were CD, that person turned out to be the victim, and so he arranges to purchase an ounce of marijuana from that individual at Antioch Park. And so this defendant then goes to a McDonald's, and his friend goes with him, and then also this defendant's girlfriend comes along, and then the defendant's older brother is there as well. So they're using the friend's pickup truck. The older brother of this defendant is driving the truck. He's in the driver's seat. In the front passenger seat of the truck is the friend. In the rear passenger side seat is this defendant, and in the rear driver's side seat is the girlfriend. So that's their positioning in the truck. They discussed their plan at the McDonald's, which was basically a not thoroughly well thought out plan, which basically was just to grab the marijuana and drive away without paying for it. This defendant had prepared a $20 a roll of cash with a $20 bill wrapped around a bunch of ones with a rubber band on it, and the friend speculated that was just sort of a backup plan in case the seller of the marijuana demanded cash before he handed over the marijuana.
Mr. Christian, let me interrupt you a second. What is the act that's involved? Is the act the words, or is the act that caused the death the rapid driving? And it appears that Judge Fuente found that the rapid driving in a reckless manner is what caused the death.
Well, because the jury was instructed here on both manslaughter by culpable negligence and manslaughter by act,
But even the culpable negligence would require more than words.
Well, culpable negligence would require a course of conduct evincing a reckless disregard for human life. So, I would agree that...
Point to those facts in the record that evince a reckless disregard on behalf of this defendant.
Yes, Judge. The course of conduct here, the acts that we're talking about, is basically continuing to drive with the victim, hanging on to the side of the car.
So as a principle, we would have to conclude that the evidence shows that he directed his brother to continue to drive in the manner that caused the death.
That the evidence would be sufficient from which the jury could find that this defendant, incited, caused, or encouraged his brother to continue in that course of action. And so it's his words shouting, hit him or hit his hands. Regarding the words, I would emphasize that those, not only they're saying hit his hands, but it's also saying, hey, let's ditch this guy. I think that's a reasonable inference. The victim is yelling, please stop, so they can either stop and let the guy off and have a confrontation with the guy, presumably, or something like that, or they can keep driving and try to knock the guy off. So that's...
Well, if he yells at the driver to hit his hands or hit him, is that an encouragement to keep driving as he was driving, or to speed up, or whatever?
I believe that's a reasonable inference to be drawn on these facts. The victim was this defendant's contact. So this defendant is the one who knows him. He's set this up. He's orchestrated the thing. The brother's driving. He doesn't necessarily even know the guy. So when they're presented with this problem of, hey, we've got a drug dealer hanging onto the side of our car, what do we do? And this defendant says, hit his hands. I mean, I think one of the things that is saying is, hey, don't slow down and let's keep driving, because the evidence was that the victim shouted, please stop, please stop. That was according to the girlfriend's testimony. She can apparently hear that over the modified exhaust of the truck. So there's evidence that they should have been able to hear, that they did hear the victim saying, please stop. They don't stop. This defendant's response to that is to say, hit his hands, and then the evidence is that is what the older brother did, that he did hit his hands 2 or 3 times, and that's when the victim fell from the car. So the trial court's reasoning was simply that the words, that the act of shouting "hit his hands" was not enough by itself to support the conviction for manslaughter. The state's position is simply that those words were enough to support the conviction for manslaughter. Those words made him a principal
to manslaughter.
Right. Those words made him a principal to manslaughter because he certainly encouraged, he incited, he advised his brother to take this action, and that's what his brother did, and that's resulting in the victim's death.
Does the charge of principal require more of a specific intent in contrast to a straightforward manslaughter charge?
It does have an intent element. It required that he had a conscious intent that the act be done. And so, if we're talking about manslaughter by act, then we're talking about the acts of continuing to drive and hitting the victim's hands. Manslaughter by culpable negligence, I would think he would need to intend that the course of conduct be done. I think that's how the instruction would be interpreted. Then the principal instruction also requires that he did some act or said some word. It actually includes the possibility of allowing someone to be a principal based only on the words, that he did some act or said some word which was intended to and which did cause, incite, encourage, or advise the other person to commit the acts which constituted the charged offense. So the trial court's reasoning, again, the trial court simply said, well, these words are not sufficient by themselves to support the conviction. The court also sort of opined or reasoned that these were inconsistent verdicts or interlocking verdicts, and again, the jury came back with acquitting both defendants on the charge of felony murder and instead finding them guilty of the lesser offense of manslaughter. And the jury then said, well, no, this isn't robbery, this is a theft. So the trial court took that acquittal of robbery and said, well, maybe if the jury had found him guilty of robbery, then that would imply that force was used, and so maybe that would help. Maybe the result would be different.
Well, he planned the robbery.
Right. They certainly planned a theft. Whether the force was used, I don't think.
Assume the jury found him guilty of robbery. The robbery that he was found guilty of, he was involved in planning and carrying out.
Correct.
So then now we're talking felony murder.
Right.
And I think that's maybe why the judge said what he said. But when you take it away from the felony murder rule, and now you're analyzing it from a principle perspective, now we get into these sticky problems about is telling the brother to hit his hands, sufficient.
Right. So again, the state's emphasizing that these words by themselves were enough. Let's see. As far as the defendant's arguments, The defendant mentions Haygood, and I would agree with the defendant that Haygood's not applicable here. This wasn't a case where we had the flawed instruction on manslaughter. The defendant suggests that based on his research, he didn't find any case law in Florida saying that merely using words is enough to find someone to support a conviction for manslaughter. On that issue, again, I would just return to the principal instruction, which allows someone to be a principal to an offense based solely on their words. It uses the alternative so that you can have that the defendant did some act or said some words which were intended to and which did incite the acts to be done that constituted manslaughter.
Is there anything else that this gentleman did that would support the state's position that he was involved in encouraging or inciting, other than to say hit his hands or hit him?
Well, not specifically. There were some discussions after the fact that would indicate their awareness of what, that they may have been aware that that this victim was hurt or was injured. This defendant did want to go back to the scene and check on him. The girlfriend discouraged him from doing that. She said, I think maybe he's fine. And so then they learned I think it was on Facebook shortly after that the victim was in the hospital and then passed away. But not specifically. I mean, his role is the phone calls. He sets up the situation. He has the roll of 20s. He's in the back seat. And then from there, it's just a matter of the friend testifying and the girlfriend testifying. I mean, that's the testimony regarding what this defendant's role in the manslaughter was. So really the state is relying largely on his conduct of shouting.
So his involvement in setting up this whole scenario of stealing the marijuana doesn't really help you.
Well, I would suggest that it does, to the extent that the victim is the contact. The victim is this defendant's contact. So, and the reason that I'm emphasizing or making that point is just that the guy driving doesn't really know this kid. I mean, the victim is as a juvenile too. He doesn't know this person who's hanging off the side of his car. They're purchasing marijuana from someone that this defendant knew. So whether, what they choose to do about the situation, I think it's reasonable that the brother would perhaps defer to the little brother in the back seat, who's the one who set the whole thing up. I mean, if this little brother knows the guy and wants to let him go, or wants to stop and say, all right, we were just messing around, or okay, we'll pay you, or here, we'll give you the $20. I mean, they could have done that, and the brother could have just slowed down, but this defendant's actions were to say, hit his hands, let's knock him off. And the testimony was that, the accident reconstruction testimony was that the truck was traveling at about 40 miles an hour at the time that the victim, hit the pavement.
So you're saying that the defendant's involvement in setting up the scenario and knowing the victim would give his instruction to hit his hands or hit him additional persuasive power?
Yes, I think it gives additional weight to that. That the older brother is basically following the younger brother's, directive. And the girlfriend's testimony was that, that this defendant said hit his hands, and that then it was after that the older brother hit his hands. The testimony in the record was also that the friend testified that he didn't believe that the older brother slowed down at all. He heard the tires screeching. The older brother floored the gas. So, they're getting out of there. They're trying to get out of there as fast as they can.
Although the record seems to indicate that these circumstances happened over a span of something less than 5 minutes, doesn't the testimony reflect that as soon as they stole the marijuana, the brother driver immediately sped off with no directions from anyone?
That's
So
correct.
his manner of driving was his own choice.
Well, that was certainly part of the plan from the beginning, but then they're presented with this other circumstance of, they've got a human being holding onto the side of the car. Obviously, that wasn't part of the plan. The testimony was that, I believe it was a friend who guesstimated that this whole course of the driving away from the time that they floored the gas until the victim fell was between about 10 to 15 seconds. So, I mean, it's not a significant amount of time, although 15 seconds holding onto the side of a car, I mean, that's, it's not a small amount of time.
You gotta
either.
wonder, though, about someone's sense of time in that situation.
Sure.
I mean, I have trouble imagining someone hanging onto the side of a car going 40 miles an hour for 15 seconds.
Right. And although, I mean, based on where the victim was found, he did at least hold on long enough for them to exit the park and then make a right turn, and then he was found alongside the road there by someone who was walking his dog later that night. If the panel has any further questions, otherwise the state would respectfully ask the court to reverse the lower court's entry of the judgment of acquittal and remand the case for entry of a judgment of manslaughter.
Okay, we have about 4 minutes left.
Sure, thanks.
Excuse me, if it pleases the court. Scott Swartz, standing in for Joseph Sexton. Your Honor, I'd like to address that last issue that was just being discussed in regards to the driving behavior from the co-defendant in this case. As been correctly pointed out, at no point does that behavior change. That driver makes the immediate decision, floors the car, floors the accelerator. That's uncontroverted in the testimony. Immediately steps on the gas, takes off. There's absolutely no change. There is no words, there is no evidence at all that the appellee made any statements to the driver in regards to speed up, slow down, stop, anything along those lines. He does not make any comment whatsoever, makes no actions whatsoever from his location in the rear passenger side seat that would indicate any desire about the driving behavior, which, as both counsel and your honors have pointed out, it was the immediate cause of the victim's unfortunate passing. Judge Fuente, in his decision, directly points out that it is that driving behavior that resulted in the death. I'd also like to address the idea that the appellee was somehow the absolute mastermind behind the entire thing, simply because he knew this person. And yes, the evidence does show that he was involved in planning of the theft as a separate issue than the driving that resulted in his death. The idea that the older brother wasn't the one that was actually in control of the vehicle, and if the younger brother is running the show, why is the older brother driving the truck? The truck doesn't even belong to either one of them, but the older brother is the one that's suddenly given control of the situation, given the keys to the witnesses, I guess is slightly lesser charged co-defendant in the passenger seat, the front passenger seat's vehicle. The younger brother, the appellee, back passenger seat, absolutely no control over the actual situation that's occurring. I'd also like to point out, Your Honors, that I want to just distinguish a couple cases that were not brought up in counsel's argument, but were mentioned in his brief. In that brief, they do discuss Brown v. State, 966 Southern 2nd, 989. And that case is distinguishable from this case. And in that case, the person was ended up determined that there was enough evidence for them to be found guilty of manslaughter. But in that particular case, it's an entirely different set of facts. In that case, there was a decision to essentially carjack someone. The defendant in that case knew that the co-defendant had a gun, knew that the co-defendant was going to use a gun, and actively participated in pulling someone out of the car. And in that situation, that particular type of case, where the court ended up ruling that there was sufficient evidence, that shows not only actual acts, but actual knowledge of a gun that was going to be used in totally separate sort of situation, where in this, there is no act at all by the appellee that resulted in the unfortunate death of the victim.
Well, what weight should we give to the statement, hit him or hit his hands? Isn't that certainly an encouragement or incitement for the older brother to continue to drive and continue in his course of action and in fact make it worse by making sure that this victim falls from the car?
Well, Your Honor, I don't think that we can attribute hit his hands to the driving, the manner of his driving. That is not saying, hey, speed up. Hey, shake the wheel.
It sure isn't saying slow down. This guy's in trouble.
That's true, but he's not required to say slow down, he's in trouble. And it is the manner of his driving that starts immediately upon the co-defendant's decision to floor the accelerator and spin the wheel while going out of the parking lot that causes the victim to fall off the truck. That is the determination that Judge Fuente used in determining that was what ended up causing the death. And saying hit his hands is not, hey, speed up, or try to shake him loose.
It sounds like your argument is that we need to compartmentalize the driving from hit his hands and view them as separate, unrelated events.
Well, Your Honor, what I'm saying is that I believe that it was the driving, the manner in which the co-defendant was driving that caused the victim to fall off the car. The alleged statement of hit his hands was actually only reported by one of the witnesses. The other witness mentions that no one said anything. And so while that goes to the weight and the credibility of the witnesses, and it's perhaps a separate issue, the point is that what I believe the evidence shows is the reason that person fell was due to the brother's driving. And the appellee in this case does not make any comments as to the manner in which he is driving. And while he may have said that, and one of the witnesses did report him saying that, what caused the victim to fall was the manner in which the co-defendant decided to drive. And that was in no way discussed or contributed to by the appellee who's sitting in the rear passenger seat. I'd also like to point out just a few things as well from some of the other cases cited by the state in their brief. State versus Sherrod, 992 Southern 2nd. Sorry. 992 Southern 2nd, 900. In both that case and State v. Smiley, which is 646 Southern 2nd, 238, as well as, I'm sorry, just in those two cases, the issues there where the court did reverse the decision to grant the JOA, that's in a situation where the trial court specifically said, and it's clear in the record, that his reasoning for granting the JOA was because of the weight of the evidence, not the sufficiency of the evidence. In this particular case, in Judge Fuente's written order granting the judgment of acquittal, pages 6 through 8, in his analysis of that 11-page document, he specifically addresses that it is the sufficiency of the evidence is his reason for granting the judgment of acquittal, that the evidence that was presented was not sufficient to sustain a conviction for manslaughter. And that distinguishes it from those two cases where the judgment of acquittal, the decision to grant a judgment of acquittal was reversed. And he specifically states that the mere statement hit his hands as the only particular evidence that was presented by the state is not sufficient to find him guilty of manslaughter even as a principal. And we'd argue that that is the correct decision. regards to the principal, excuse me, as far as principal to manslaughter, obviously intent is required as far as the argument for the principal theory, but he has a conscious intent that a crime be done, in particular in manslaughter, that intent is not a element of that in manslaughter, and that would require the state to prove that he intended to commit an unintentional act. If the court doesn't have any other questions, I have nothing further.
Thank you, Mr. Schwartz.
Thank you.
Regarding the appellee's position that the older brother basically did this all on his own, again, the course of conduct that's at issue here is it includes the driving, the failing to stop, continuing to drive, and then hitting the victim's hands, causing him to fall from the truck. So on that point, I would just emphasize that the jury was instructed in this case on independent act. So the jury had the opportunity to consider that the brother, hatched this idea to knock the victim off solely on his own. The jury obviously rejected that and, found both defendants guilty of manslaughter. The other point that I wanted to make is that regarding the failure to stop, I think the defense argued that that this defendant didn't have a duty to act, but because culpable negligence can be committed through omissions, so if those omissions are such that they would evince a reckless disregard for human life. So once they've created the situation, they have a victim hanging off the side of their car, and then they're taking this course of conduct. I think that the failure to stop is at least part of the evidence that the jury can consider in deciding whether to find this defendant guilty of manslaughter by culpable negligence. One other point, the defense mentioned that the fact that the older brother was driving the truck. The testimony in the record was just that the older brother had previously driven the truck. So among the friends who were involved in this, I guess the friend didn't want to drive, and the older brother was the one who had driven this truck before. So I think to these kids it just kind of made sense that the older brother would drive it. And again, I mean, once we're talking about that kind of issue, I think that the question is whether the evidence was sufficient, and I think that the state, again, presented sufficient evidence from which the jury could find this defendant guilty of either manslaughter by act or manslaughter by culpable negligence as a principle. Unless the panel has any further questions. Thank you.
Thank you, Mr. Christian.